Here's an oversimplification of how court decisions impact existing laws. A case is decided in a trial court and a sentence is handed down by a trial judge. One of the parties does not agree with that decision, so maybe they appeal to a higher court, and that court issues its own decision. Affirm, reverse, remand. Regardless of where a case stops, the final decision in that case's journey through the courts becomes a binding precedent, influencing how the law at the center of the case is enforced going forward. In other words, courts play an active role in clarifying, reshaping, and refining existing laws. They don't just interpret them. But what about laws before they even become laws? Who pens the first drafts or even the revised drafts once courts expose flaws in existing policy? And then how is congressional support cultivated to push legislation to the finish line? For industry, you might refer to these operatives as lobbyists. But for broader goals and social change, we call them advocates. Until recently, policy advocates learned the skills necessary to be effective organizers by exposure, on the job, on the go, sink or swim. But recently, a more structured means of gaining advocacy experience has emerged. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. In this episode, we're stepping outside the courtroom and into the classroom, where the next generation of criminal justice advocates are learning the ropes. And in the process, they're reviving interest in the Equal Act to eliminate the crack powder cocaine sentencing disparity once and for all. If you like what you hear in today's episode, visit go.osu.edu/drugsonthedocket to follow the series. Well, it's not the first time we've departed from our usual subject matter to highlight what's going on more generally in the world of drug enforcement and policy, but I'm especially looking forward to this conversation because we're getting an inside look at what it takes to be effective in the fight for meaningful criminal justice reform, as in like influencing legislation and lawmakers. So policy people, this one's for you. With that, Doug, will you do us the honor of introducing our guest?
Thank you so much, Hannah. I am so very pleased to have Udi Ofer with us today. Udi has more than 20 years of experience as a human rights lawyer, tackling issues ranging from criminal justice reform to national security, free speech, and racial justice. He is the founding director of an amazing policy advocacy clinic at Princeton University, which we'll be talking about. And he's also a visiting professor at Princeton School of Public and International Affairs, also known as SPIA. Before joining Princeton, he had an impressive 20-year tenure with the Americans with Civil Liberties Union, where among many accomplishments, Udi oversaw the ACLU's Campaign for Smart Justice, which was its 50-state strategy to end mass incarceration. Udi's work has been published in academic journals. His commentary has been featured in hundreds of news outlets, and he's been cited in more than 100 law review articles, as well as in many legal opinions. I could go on, but without further ado, I just want to say thanks for joining us, Udi. I'm very much looking forward to our conversation.
It's great to be here. I'm a big fan.
Let's jump right into the Policy Advocacy Clinic. So it's an immersive undergraduate clinic that aims to equip and inspire the next generation of policymakers, advocates, and social movement builders. Tall order. How did you get the idea to create this learning opportunity, and what is it about this experience that sets it apart from maybe more traditional public policy curriculum?
When I started teaching, two things became clear to me early on. First, that students were hungry for real-world application of their passion for policy. The students have been gaining a first-rate education at Princeton on policy theory, quantitative analysis, but it felt a bit detached to them from the policy issues that they were seeing play out in their lives outside of school. Second, I also saw the students weren't learning enough applied skills, right? Such as how do you draft a policy analysis memo? How do you put together a campaign advocacy plan, right? How do you conduct a power mapping feasibility test? When I was at the ACLU for 20 years, I hired hundreds of people, right, for positions like policy counsel, campaign strategist. And I knew the skills that I needed at that time to see as a manager. And I just wasn't seeing it being taught.
I totally get and think it's a powerful insight that students, undergraduate and law students, kind of need to know how to take their learning and make it applied, make it combined with a set of skills that will really make an impact in the real world in a variety of settings. But I think there's a perception, maybe an accurate perception, that in a lot of academic settings, that's not really what we're supposed to be focused on. We're supposed to be focused on high theory and big ideas. And I certainly know that there's a fear among some academics that if they focus on implementation or skills-based learning, that's not as respected or even valued the same level as big ideas. And so was it a challenge to get Princeton to embrace the idea that you'd develop a whole class and a clinic around those kinds of skill-based implementation commitments rather than just the big ideas, even though you clearly cover a bunch of big ideas in the clinic?
I think there's a recognition that this is complementary to the other work that is happening. And I think it makes the Princeton education much more well-rounded. Personally, I think we need both. We need the sophisticated quantitative data analysis. We need the theory-based learning, but we also need the applied learning. The challenge is to do the applied learning in a nonpartisan manner, which is incredibly important and something that I take a lot of pride in. The challenge is to make the applied learning as rigorous and as sophisticated. And we really have tried to do that as much as possible. A lot of what I'm trying to model here is similar to a law school clinic model, right? But the difference is this is policy and these are undergrad. But the idea is to give students firsthand learning in what it takes to engage in policy advocacy, to try to immerse them in what does it look like to work in real life policy advocacy settings, act like a full-time policy advocate, and all under the close supervision of the clinical professor. Part of what makes it unique is that it's a year-long program. In the first semester, students learn about policy advocacy theory. They learn about the legislative process in a sophisticated way where they're like reading, the rules of the legislatures. They learn about administrative law. They learn how to do sophisticated policy analysis. And then what makes the clinic the most innovative is that then they also learn campaign planning and things like power mapping. Basically, a process that forces you to be honest about whether you can actually achieve the policy goal that you want to achieve. Very, very, very few schools teach this. But in the real world, if you work for an organization like an ACLU, you're going to be exposed to this kind of thinking. So that's the first semester, which is pretty intense. And then the second semester, students are put in a policy advocacy setting. We've been working a lot with the United Nations in really exciting ways, something on the federal level, and then something at the state and local level. So it's important for me for students to realize that there are different levels of policy advocacy. As far as I can tell, there's nothing like this in the country for undergraduates, right? There are some law schools that do have policy advocacy clinics, like Berkeley Law School, but again, that's for law students.
So is it true that the Policy Advocacy Clinic, is it the first clinic of its kind for undergraduate students?
So look, as far as I can tell, there's nothing like this in the country for undergraduates. Cornell recently started a policy advocacy clinic for undergrads in its policy program, but it is a bit different.
I'm curious, what do stakeholders think about the clinic and the work your students have done so far?
I get feedback both from students in the sense of it becomes their defining experience at Princeton. But then I'm getting a lot of feedback from the advocacy space, right, where they're thanking us for fulfilling a role that they couldn't otherwise fulfill. And that's been one of the most rewarding parts, in that I feel like we are contributing to ongoing work out in the advocacy space.
It sounds like an incredible exercise, and I can see students learning so much and having so many of their own insights, and then getting challenged on those insights as to, where power resides and the influence that they could have. One of the things that makes law school clinics, I won't quite say easier, but the topic's already defined and students know when they come in, kind of what they're interested in and subject matter. How do you pick what topics you're going to focus on? Is that something that you are picking ahead of time, or are you giving students options? Are they coming in with ideas? And I guess specifically, how did the Equal Act and the crack powder debate become a focal point for student work last year?
What I do is usually come up with a menu of options, and then we have discussions and students decide what the projects are. Look, the biggest challenge for the clinical professor in the policy advocacy space is finding a policy project that is ripe and that is in the right moment of what we call the policy cycle, where the students can actually help that policy cycle move along. And that can fit into the semester model. Not to say that litigation is all that different, but in some ways, there's more clarity in litigation in the sense of you have the rules of civil procedure, there are timelines, there are certain benchmarks that are very predictable. Like you're going to file a complaint. There's a statute of limitations of when you're going to file a complaint. After filing the complaint, there'll be a motion to dismiss, discovery, summary judgment, whatever. You know the process. In the policy advocacy space, it's a bit more challenging in the sense of while there are predictable timelines in the sense of there's a legislative session and there's a beginning date and an end date, everything around it is a bit more up in the air and you don't have as much control over it. In the fall, the students learn skills that could be applied no matter the subject matter that they're working on. To make a law school analogy, it's the equivalent of learning the rules of civil procedure, of learning how to draft a complaint, of learning motion practice. So having that equivalent in the policy advocacy space, that then they could be plugged in whatever is an active campaign. Their final paper in the fall semester relates to the research that they will do in the spring semester. So they begin to develop an expertise. I also make sure to find policy projects that are not too overwhelming in the sense of the student can really become an expert on it.
Based on your experience having been with the ACLU for all those years, do you find that legislators and other policymakers are actually more open to hearing from a group of students than they are from a traditional advocacy group?
I'll give you a concrete example from a couple of weeks ago. So we were down in the Louisiana State Capitol in Baton Rouge, and we worked with an advocate who had been involved in state politics, I think for like 15 years, maybe even 20 years. It was the first time he had ever been invited to the Republican Legislative Caucus. My guess is one of the reasons there was openness was because it was Princeton University students coming in. Also, I will say this, the framing that I use with my students, the research findings, it is different than what they would have written if they were representing the ACLU. The ACLU has a set of principles, has a set of values, and everything guides that. The analysis that the students are doing are really just meant to be, I don't know if neutral is the right word, but at least, stripped of any sense of potential bias whatsoever. All my students go through at least 4 drafts of their final product. And usually between first draft and second draft is when I strip a lot of the loaded words.
How does engaging with an international organization differ compared to engaging with the local level?
You really have to go a bit more into the basics of explaining the constitutional structure, particularly in the criminal justice system, right? If you're dealing with policing, you usually have to start off by saying there are 18,000 local law enforcement agencies in the United States under principles of federalism. They're under state and local control. You have to get into how is the United States structured. When you're dealing with, lawmakers in Baton Rouge, Louisiana, or even with congressional lawmakers, you don't have to deal with that at all. So substantively, there are differences. But then look, there's also cultural differences. The students also, interestingly, though, when they're testifying before the Human Rights Council in that Palais des Nations in Geneva, which is this gorgeous building, you adjust how you talk about the issues. Look, part of policy advocacy is knowing your audience, right? So we go through a lot of strategic thinking around what is the best way to deliver your message. And there are different strategies associated with delivering your message to a UN audience than there is to a Baton Rouge, Louisiana audience.
I'm going to use that to transition to the work you and your students did on that report about crack sentencing and the Equal Act, which addressed federal stories, but also highlighted state developments, provided a lot of data, but did in a sort of a compact way that was so valuable. I'd love to hear more about both, working with the students on that project, and then whether you think the crack powder issues could become front burner again in the years ahead.
Oh man, you're touching on all my favorite things. I love it. The clinic model, as I mentioned, is meant to fill a void in the policy advocacy space. So right before the 2023 to 2024 academic year, I talked to various advocates across the country and quickly realized that there was a need for further analysis of the Equal Act, right, which had been pending in Congress. And you're right, at that time had a lot of bipartisan support, and I would argue still does. So after meeting with both advocates on the left and on the right, and specifically the Justice Action Network, we decided to work on a project to analyze the impact of the Equal Act should it pass Congress. And I got to say, we received so much enthusiasm for this, including from Congress members. For example, Congressmember Kelly Armstrong, who's now the governor of North Dakota, he's a conservative Republican, And he is passionate about this issue. But it was clear to us that the momentum for the Equal Act was hanging on a string in some ways. This is the period when the backlash against criminal justice reform was just beginning to gain more steam. And we were trying to position this issue as above partisan divides.
Curious to how you would describe what the Equal Act does, just in simple terms.
The Equal Act would end the sentencing disparities between crack and powder cocaine, which were initially created in 1986 as part of the Anti-Drug Abuse Act. You would receive a mandatory minimum sentence whether you had, 5 grams of crack cocaine as 500 grams of powder cocaine. Disparities about the weight and the mandatory minimum that it would trigger. So it's the same mandatory minimum that would be triggered, but there's 100-to-1 disparity between the weight. In 2010, President Obama worked with Republicans to pass the Fair Sentencing Act that reduced that disparity from 100-to-1 to 18-to-1. And really what I consider the beginning of what I call the golden age period of the bipartisan criminal justice reform movement. Then 2018 First Step Act, which is kind of the peak of the Republican support for the criminal justice reform movement, retroactively applied the Fair Sentencing Act's reduction of the sentencing disparity. And then comes the Equal Act, which was meant to eliminate the sentencing disparity altogether. The weight of crack cocaine would be treated the same way as the weight of powder cocaine, and it would apply retroactively. It's a very simple act. If you pull up the bill, it's like a page long. It essentially just deletes the sections in federal law that treats crack cocaine differently than powder cocaine. As the Equal Act was stalling, there were other attempts to try to address what was being recognized as the harm caused by the sentencing disparity through the executive branch, right? So in December of 2022, Attorney General Garland issued a memo that asked his line prosecutors, when making sentencing decisions, to treat crack cocaine in the same way as powder cocaine. Now, there were exceptions to that, but the Garland memo was the beginning of kind of chipping away at what has been recognized as one of the greatest drivers of racial disparities in the federal criminal justice system.
Do you think that memo really had any significant impact?
We talked to folks within justice headquarters on this question. I talked to federal defenders. I talked to prosecutors asking this question, like, what was the impact of the Garland memo? I felt like it would have been irresponsible for my students to include this as a finding in their briefer, but I could share with you in a more informal way that I do think there's a recognition that it made an impact. That it is one of the main reasons that we have seen a dramatic decrease in racial disparities in crack cocaine prosecutions. Now, at the same time, we haven't seen that type of decrease in powder cocaine prosecutions. One of the most fascinating findings of the briefer was that the decrease in crack cocaine sentencing was much higher than any change to the powder cocaine sentencing.
When I saw that the Latino population seemed to be disproportionately represented for powder cocaine convictions, I was like, okay, so what's going on?
We also wanted to get an answer to that. And again, I didn't include it as a finding because I didn't feel like we had enough data to do so. But I do feel comfortable saying here that, the driver of that was really the increase in immigration enforcement. And while we constantly were hearing from public defenders or we're hearing from justice officials, is that as Customs and Border Protection increased their enforcement of the southern border and was facing political pressures, right, to arrest more people trying to enter through the southern border, we saw powder cocaine prosecutions increase. Powder cocaine is smuggled into the country or trafficked into the country, and then inside the United States, it's converted into crack cocaine. So in many ways, what we were seeing is that more people began to be arrested in the southern border for trying to traffic in powder cocaine. And then we saw a decrease in emphasis on heavily prosecuting very low-level street corner guys for, distributing crack cocaine. I think that is the story that's being told through this data.
So many of the things that you said, Udi, are a reminder of why changes in law rather than changes in discretion are necessary, not just for enduring change, right? So, in case anyone's not aware, when Trump came to office and Attorney General Bondi took over, she rescinded the Garland memo that instructed federal prosecutors to treat crack as if it's mostly like powder weight. But also, were there the passage of the Equal Act, the Sentencing Commission, a whole bunch of other data collectors would have law as the basis for studying and analyzing these differences when it's just a matter of discretion. And even, the work that you and your students did is a reminder of that. You can't capture that quite the same way. You can make speculations. You can, have some theories of the case of what's going on and how this is echoing through the system. But ultimately, if you don't get something like the Equal Act passed, it's not going to be equal in law. And as a result, it's going to be hard to tell whether even equal in practice really means that.
Can I say something about the Bondi memo? In February 2025, Attorney General Pam Bondi issues her version of these, charging memos, and she does obviously repeal the Garland memo, but she retains prosecutorial discretion. This is like a point that I think both the left and the right can be a bit more honest about, right? Because both the left and the right don't like prosecutorial discretion when the discretion is not moving in the direction that they want to move. So it's very highly politicized. But if you read the Pam Bondi memo, right, she includes carve-outs for prosecutors for when they can charge a less serious crime. The memo says it. Right now, it's about, circumstances where in good judgment will lead a prosecutor to conclude that this would be unfair or inconsistent. So she allows for that discretion. Also, her memo states what are the top enforcement priorities for her DOJ, with number one being immigration enforcement, number two being human trafficking, and then she talks about transnational crime. The narrative that I think some people have developed is that the Trump administration tries to say they're just following the letter of the law, they're just going to enforce the law. But no, there is discretion literally built into the memos being issued by the Justice Department. It's just enforcement priorities have changed. And that's a political decision.
You mentioned earlier you thought that there were some Republicans that might be even more supportive of the Equal Act than some Democrats. Obviously, as of the time we're taping this, the Republicans are in complete control of the presidency and both houses of Congress. Absolutely, a lot of other issues clearly have priority in the work that they're doing. But I wonder if you think the Equal Act still could possibly have legs. Who would be sort of critical players here? As I imagine the 2025 power map, it probably looks a lot different than the 2022 power map, but there still is a lot of power out there.
I want to create a distinction here between the criminal justice reform movement advocacy space and then Republican and Democratic lawmakers. In the advocacy space, I think it's fair to say that the conservative flank of the movement, the conservative movement for criminal justice reform, has prioritized Equal Act historically, and I think continue to some extent. Groups like Americans for Tax Reform, American Conservative Union, Faith and Freedom Coalition, right, which is the pact for the evangelical right. FAM, although, are they conservative or not, that's fine. Justice Action Network. Even the Association of Prosecuting Attorneys, they have long prioritized the Equal Act. The left flank of the movement, obviously supportive of the Equal Act. There's no question about it. They've been leading this effort in many, all the way back since the 1980s. But I think they see it as too little in some ways, right? Because it maintains mandatory minimums and it doesn't go far enough. So while they'll show up to the lobby day, they'll sign on to the letter, my experience is that they're not the ones who are driving it. Within Congress, though, I will say that while there has been Republican support for it, it hasn't been reintroduced in the 119th Congress yet. In the House, it had 23 co-sponsors, right? 13 Dems and 10 Republicans. In the Senate, it had 10 co-sponsors, 5 Republicans, 5 Democrats. Democrats are still the ones who are pushing it more inside. So you have Cory Booker in the Senate, you have Hakeem Jeffries in the House. When Kelly Armstrong was in the House, he was the big champion. Dick Durbin is also a champion, right? So I don't want to overstate the tension, but there is a bit of a tension. Having said all that, I could tell you, look, we are talking in June of 2025. We are 150 days into the second Trump administration. Don't count my math yet, but we're beyond the first 100 days. We always knew that in the first 100 days of the Trump administration, all of the culture war issues were going to be front and center. So in the advocacy space, we had that conversation. Let's let everyone get it out of their system. And then the idea is, as the further we move away from Inauguration Day, from January 20th, the closer we get to the midterms. And then depending on what happens in the midterms, that is then the window to once again have some sort of bipartisan criminal justice reform on the federal level. And I feel confident saying it is still very much on the table. I took my students to CPAC last year and this year, which will probably shock many of you. This is the Conservative Political Action Conference. It's the annual conference that happens just outside of DC every year. And the reason I take my students there is that for the last several years, there's been a day that is dedicated solely to criminal justice reform by conservatives for conservatives. And I think it's really important for us, to attend it. This year at that session, the polling firm that does polling for the Trump White House, so President Trump's pollster, presented on why he believes that criminal justice reform is a good issue for President Trump. And he literally presented data at CPAC on why supporting, various criminal justice reforms will not only satisfy the Republican base, but will actually expand the base. He said that he has shown that polling to the White House, to the president's circle. We know that there are conversations happening inside the White House on a Second Step Act. The Equal Act and variations of it are all in that ecosystem. So, the fight is definitely not over. The politics are certainly more complicated. What I always like to tell advocates, particularly advocates on the left, is that they need to be able to hold two thoughts at the same time on this issue. One, the Republicans have led the backlash on criminal justice reform. But second, many Republicans continue to support and some champion criminal justice reform. And both facts are true. And it's important to recognize that. And there's a debate within the Republican Party right now around what role should criminal justice reform happen. And it's not a monolithic party. What I try to do is try to position our clinic in a nonpartisan way that just helps inform all policymakers, whether you're Republican, whether you're a Democrat. And I got to say, we're talking now on June 5th, 2 days ago, Princeton, along with 14 other organizations and Council on Criminal Justice and the Just Trust, launched these bipartisan principles on criminal justice reform. This is a project that I've been working on for about a year and a half, where we wanted to bring 7 leading organizations from the left, 7 from the right, so groups like ACLU and CPAC, in the same room to try to agree on bipartisan principles on criminal justice reform. We had a 2-day convening at Princeton, which was like a mini constitutional convention. It was amazing. And the 14 organizations that agree on nothing else agreed on 4 unifying principles to guide criminal justice policymaking. And the idea is to once again show that in this, sea of political bickering, there's this island of agreement when it comes to criminal justice reform. So the Equal Act and variations of it are very much on the table. When my students researched criminal justice reform in the South, they saw a ton of support among Republicans for drug diversion programs, for drug courts, also support for raising the quantity threshold for drug offenses, lowering mandatory minimums. We have made progress as a nation. I know it doesn't feel that way, but we have. So we got to get through this period. And my hope is closer to the midterms, or actually more likely right after the midterms, we will see bipartisan criminal justice reform on the federal level happen. And the last thing I'll say is, because it's happening in the states, literally every month you have a state that passes bipartisan criminal justice reform. I keep a database of all of this. I have, captured at least 19 state bipartisan bills that have passed in 2025 alone, including on this issue. Both Virginia and Arizona ended their state's sentencing disparity between crack and powder cocaine. That just happened in the last few months. So one of the things we're trying to do is to show the federal government that the states are leading on this issue, and to use kind of a federalism frame as a way to advocate for the federal government to catch up and to end its own sentencing disparities when it comes to crack and powder cocaine. And I do think that resonates.
Do you think that motivation matters when it comes to policy? Like in Ohio, for instance, we had legislation introduced last year called the GROW Act, Get Rehabilitated Offenders Working, right? So in terms of talking to Republicans versus talking to Democrats about criminal justice issues, I have to incentivize lawmakers differently or bring up points here differently or not mention things over here. Do you find that to be the case? I mean, has there been a qualitative analysis of like, what are these bills called? And do we see a difference in the way that criminal justice reform is talked about, like why we're doing it?
That is a great question. I don't see this as an issue of motivation. I see this as an issue of values. And I think that is key to any good policy advocacy. One of the things I teach my students is when a policymaker doesn't act your way, your response should not be to get more angry at that policymaker. Your response should be, what am I, as the policy advocate, doing wrong so that it's not in the interest of that policymaker to act the way you want them to act, which is a totally different way to look at it. So I don't see it as motivation as much as I see people are guided by different value systems. Oftentimes for a Republican audience, I don't want to be, too sweeping here, but I'll make some generalizations. Public safety is the top message. They need to know that safety is being taken seriously. And once they feel that confidence that, okay, you care about my safety, even though the data may show that subway crime is down, I feel unsafe. And I need you to take that seriously. But what the data shows, and there's been a ton of data analysis on this, is that once people feel validated in that sense, they are then open to other values, such as fairness, such as rehabilitation, such as second chances, such as human dignity, which is why the principles that we released focused on that. Now, for a more democratic audience, the top value oftentimes is fairness. And it may go above safety to some extent. And that becomes the top message. No, I want to address this because it's unfair, right? It's unfair the way people are being treated. So I wouldn't describe it as motivations. I would describe that more as like, what are the top values that drive a certain person? And the two main political parties do have different values that drive them. What I teach my students and what I try to do in my advocacy is not to minimize any of those values, but to try to meet people where they are. And then to hold their hand to try to understand, okay, what are the other values that I think you'll care about if you felt comfortable and if there's that trust there. And I have reviewed probably like 40 polls in the last year, polling done by Republican pollsters, by Democratic pollsters, and there is consistent discomfort among voters with mandatory minimum laws, with incarcerating people who have substance abuse disorders, incarcerating people for their mental health disorders, long sentences for the sake of long sentences that don't actually make support for reentry programs, support for rehabilitation. There is actually consensus in America on these issues. I feel comfortable saying that.
Not only would I agree, I think it's especially interesting you were highlighting that typically from folks on the left of the Democratic side, there's discussion of fairness in their conversations about criminal justice concerns. I think one of the things that's remarkable about a lot of President Trump's rhetoric on a range of issues is how often he uses the term fairness, and we're being treated unfair, and this is not the way it's supposed to be, whether it's, trade or his own complaints about various aspects of justice systems. And so one sees a range of value consensus if you're looking for it. And I think the criminal justice polling reinforces that. And obviously your students are lucky to have you to help them understand that as they seek to work in this space. You did a great looking ahead in terms of the federal system, in terms of what you imagine your students working on 2 years, 5 years. The war on drugs has been going a very long time. So I'm going to give it a drugs on the docket extra focus, that particularly in the drug space. You mentioned they were seeing down south support for diversion programs and other drug court type stuff. Is there something on the horizon you think they're especially going to be working on? Obviously, the fentanyl crisis, opioids more generally became the issue of understandable focus the last couple decades, but would love to get your insights because I'm sure you're always looking ahead and now especially have to look ahead for your students' sake as well, kind of where you see some of these things going beyond having sort of that rough consensus that I think is so fundamental to making change possible.
I think the political moment that we're in right now is there's a much bigger appetite for what we call back-end reforms rather than front-end reforms. So in the drugs context, the type of back-end reforms that I do see getting a lot of momentum, and we're seeing it happening in the States, are things like clean slate legislation, right? That wipe away your record so that it doesn't remain hanging over you as you're trying to re-enter society, right? There are more than 45,000 legal restrictions on people as they leave prison. I also think more kind of second chance type laws that allow for resentencing, whether prosecutor-driven resentencing, But the types of laws that the narrative is they've been held accountable in the sense of they're sent to prison or whatever, or sentenced, but there's a questioning of whether we're doing it in an effective way. So I think in the drug context, you'll see more of an emphasis on kind of these second look laws on people who are incarcerated for drugs, even drug dealing, where there's a growing recognition that the sentence is just unfair. So I think you'll see that through prosecutor-initiated resentencing. You'll see that through the use of commutations. Right. One of the things we haven't talked about is that President Biden, one of his final acts was to commute 2,500 people from federal prison or their sentences who were essentially to try to apply the retroactivity part of the Equal Act, which was huge. We're seeing in other states like New Jersey, Governor Murphy, like doing more of that kind of stuff. So I think we'll see that. We are going to see also more just support for reentry, trying to lift the barriers that people face when they're trying to reenter society. The last thing I'll say, and this may piss off some of your listeners, so we had a panel at Princeton as part of this 2-day convening for these bipartisan principles. We're all closed door because, again, it was like a constitutional convention. But then we wanted to hold one public event. And at that event, we had David Safavian speak at it and Timothy Head. So for those of you who don't know who they are, right, David Safavian is the former general counsel for the American Conservative Union, one of the leaders of the conservative movement for criminal justice reform. Timothy Head, until a few months ago, was the head of Faith and Freedom Coalition, one of the most powerful political action committees in America for the evangelical right. And I think it was a student that asked the question, does Trump care about criminal justice reform? And his response was, and again, this is what Timothy Head said, not only does Trump see himself as a victim of the criminal justice system, see himself as a victim of overzealous prosecutors who are used their discretion in a bad way, but so does his wife, Melania. And for his wife and for the First Lady, it is now a personal issue. And they feel this affinity to people who have been abused by the criminal justice system. And they look at themselves as, they were never incarcerated, but in some ways as like, a formerly incarcerated person or someone with a felony record, which is a factual statement. I think a lot of people on the left, when you use that kind of language, that you kind of do a double take of what are you talking about? But that message resonates on the right. As you said, Doug, when Trump talks about himself, he talks about himself as a victim of a criminal justice system that's out of control. So what I've been telling the left is, don't fight him on that. Embrace it, and let's find common ground on, okay, what are the fixes that we need to see to try to make sure that whether it's a Donald Trump or a low-income person being abused. And that's where I see an opening. And that's where I want to position the type of work that my students are doing above politics and trying to find consensus and common ground.
Do you think that policy alone can course correct a lot of these areas that are you're shaking?
No, not at all. No. No, I'm very real world. I talk to my students, how culture drives policy, politics. So no, we understand it, but policy plays an important role. You need to have the policy solution that is ready for that moment in that policy cycle. And literally I have my students, there's a policy cycle that's a circle that has the different phases of policy. I have my students kind of learn those different phases and try to identify when is the role that the policy solution plays in. But that doesn't mean that policy advocacy is detached from also trying to drive narrative. How do you talk about an issue? What is the framing that you use? What is the narrative? That is driven by the power mapping. That is driven by who are actually the people in power who can change the policy that you're trying to advocate for. So no, policy alone, certainly in culture war issues, certainly in high impact issues like mass incarceration, it is not about policy alone. In fact, policy, I would say, would play a secondary or tertiary role. But that doesn't mean that policy advocates can't help lay the groundwork for cultural change. I'll use an example on this. So one of the things I have my students study is the marriage equality movement. And I was very involved in the marriage equality movement when I was at the ACLU. And I remember the moment when the movement, which always had the same policy goal, the policy goal was end discrimination against LGBT couples in marriage. They changed the narrative from a fairness narrative, an equality narrative, right? And I still say marriage equality, to a love narrative. And that was driven by a lot of polling and focus groups where they realized the case for that same policy goal, and that is ending discrimination against LGBT couples wanting to get married. While Americans got the fairness argument intellectually, when you made a love argument, they felt it. Like, why do you want to get married? Oh, because, I want equal treatment under the law. Okay, I get it. Why do you want to get married? Because I love this person and I want to spend the rest of my life with them. and I want to have kids with them, and I want to build a home with them, resonates in a totally different way. Same policy goal. It's that type of sensitivity that I try to develop in my students. Never compromise your values, be clear about your policy goal, but think about what is the best way to bring people along to your policy position.
Thank you so much, Udi. Fascinating to hear about the work you're doing there at Princeton and your broader perspectives on the range of policy advocacy issues that we've been discussing. Really, really grateful for having a chance to talk with you today and looking forward to seeing what you and your clinic and students continue to do in the months ahead. So thanks again so much.
Thank you. That was so much fun. I really enjoyed it.
Drugs on the Docket is a production of the Moritz College of Law, Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.